Good day, Crime Talk aficionados. It is Sunday. What does that mean? It's the Crime Talk weekly recap of all of our top stories throughout the week, all located in one convenient location for you to watch. I hope you enjoy it. Have a wonderful day, and we'll see you next time.
All right, lawyer.
Guess what? Denied. You don't deserve it. You don't have a right to know. The judge in the case of Richard Allen, the Delphi homicide suspect, the man accused of killing 13-year-old Abigail Williams and 14-year-old Libby German, there in Delphi, Indiana. That's right. The judge has denied yet another television station's request to have cameras in the courtroom for the trial that is going to begin next month. So, Special Judge Francis C. Gull rejected a request from a local channel in Indianapolis, which obviously makes it highly unlikely that there will be cameras allowed in probably one of the most high-profile criminal trials in the history of Indiana, at least in decades at least. Like I said, that trial was supposed to begin on May 13th. Now, the court's denial of television cameras is now the judge's fourth time that she has denied television cameras access to the court. The judge had previously rejected requests from a news channel in Fort Wayne, Indiana, and then another channel in Indianapolis, as well as two others from Fort Wayne as well. So that makes 5 total. Gee, Judge, what are you doing? Anyway, Judge Gull has only allowed cameras to access one of Mr. Allen's courtroom's hearing. That was back on October 19th when several TV stations worked together to have Court TV provide a pooled camera coverage for all participating broadcasters. Judge Gull then denied the courtroom cameras for the October 31st hearing, and the court docket cites unauthorized filming and broadcasting of pre-hearing activities in the courtroom at the October 19 hearing as the reason. Now, the courtroom camera requests from News Nation, Law and Crime, Court TV, as well as the local channels were all denied. Now, in late March, Judge Gull denied an email request from an Indiana lawyer to discuss what comes into play when deciding whether she would allow cameras in the courtroom. She did not immediately respond to the follow-up email asking if she would accept any media outlet's request to put cameras in the courtroom for Mr. Allen's trial. Why the secrecy? I mean, I get it. There's a difference between privacy and secrecy. And when things are done in secret, it's because you're probably doing bad things and you don't want other people to know what's taking place. Is that why, Judge? I don't know. This is the biggest case in Indiana. This was an unsolved cold case. Defendant has allegedly confessed. Those issues will be coming in. There's allegations of this other occult. There's questions as to the fairness of the judge. You would think the judge would say, hey, you think I'm being unfair? I'll let you see the evidence that comes in, and you decide if I was being unfair, if I was being ridiculous in my orders where I denied everything from the defense. Maybe the prosecution's evidence is so overwhelming. Wouldn't you like to see that, ladies and gentlemen? Don't you think the judge should allow that to take place? I'm a firm believer that our courtrooms should be open to everyone all the time. And as long as you don't disrupt, like I said, I believe that there should be a video feed to every courtroom. And if you're watching the morning docket on a Monday morning and motions in the afternoon, you should be able to see that, ladies and gentlemen. And I understand an open courtroom simply means that somebody can come in and watch. But it also comes down to fundamental fairness so that the world can see in big cases. And remember, we've had lots of cases over the years where people thought someone was guilty. And when you heard all the evidence, you thought, oh, I guess I see how somebody could have come to that conclusion. What comes to mind is obviously the Kyle Rittenhouse case. I was like, oh, this guy's toast, right? The evidence comes out, the kind of modifying of the video that was sent out, the self-defense, how he was attacked, whether you like him or not. The point is, everybody got to see. And there wasn't rioting and burning of the city as people had predicted because they got to see the evidence. An open society means things are open to the public, not just what the gatekeepers think that we can handle. I don't know. Maybe we're going to have to start a letter writing campaign to the judge. I'm not sure. Next, a mistrial in the George Kelly case. That's right. The Arizona rancher received a mistrial after he was accused of shooting a Mexican migrant on his land because only one of the jurors believed that he was guilty. Now, George Kelly, who's 75, ladies and gentlemen, just remember that, was accused of killing this Mexican national on January 30th, 2023, at his home in Nogales, near the Mexican border. Now, his defense attorney said that only one juror wanted to convict, and the 7 other jurors wanted to acquit. So, that one lone holdout caused the mistrial, and like I said, it was 7-1 for acquittal. So the question then becomes, what happens now? The prosecution needs to take a serious look at their case and say, hey, we had 8 jurors, 7 were not guilty. We had one lone holdout that caused a mistrial. This trial went on for a month. Do we do it again? I'm sure the prosecutors have talked to the jury to see whether they thought that their theory of prosecution was correct. Did Kelly kill this Mexican national? Or we just can't tell, and that's reasonable doubt. If that's the case, hopefully the prosecutors will do the ethically right thing to do, which is to not go forward on a case that they don't believe that they can prove beyond a reasonable doubt. And I think when a jury says 7-1 for not guilty, prosecutors have to look at their ethical responsibilities at this point. Can the prosecutors go forward? Yes, they may say, we had 7 rogue jurors and they didn't listen to the evidence and the only one person voting for guilty got it right. They could think that, but they still have that ethical obligation. Remember, prosecutors can't take a case to trial if they don't ethically believe that they could prove the case beyond a reasonable doubt. I think that is in doubt at this point. Needless to say, if the prosecution goes forward, yes, there will be a retrial. How does that affect the defense? Well, usually the defense has that one opportunity to present their evidence. Now, most of it was expert testimony, so it's not going to be a great surprise as to what's coming round 2, but the prosecution always gets to fix their case the second time around. I can just tell you the percentage of victory on a retrial goes down, crashes and burns on the second time around because the prosecution usually fixes their case. All right. If you aren't familiar with this case, prosecutors allege that Mr. Kelly recklessly fired 9 shots from an AK-47 rifle towards a group of men about 100 yards away on his cattle ranch. Kelly had said that he fired warning shots in the air, but he didn't shoot at anyone directly. Kelly was also charged with the aggravated assault against another person in the group, including a man from Honduras who was living in Mexico and who testified during the trial that he had gone into the U.S. that day seeking work. So a status hearing is set for next Monday afternoon when the prosecution will let the court know and Mr. Kelly whether they plan to proceed on the case. All right, next on the docket, the prosecutor in the Kohberger matter doesn't want to get flat-footed. That's right. Why are you saying that? Well, the prosecutor in the Kohberger matter has filed a motion, and he's requesting to do a couple of things. First, he wants to close the May 14th hearing regarding the defendant's 4th motion to compel and any hearing to be set for the defendant's 5th motion to compel. Now, apparently in the defendant's 5th supplemental request for discovery that was filed under seal, the defense is requesting the discovery, and they ordered it all to be sealed, and the court has granted that. So therefore, it makes sense that they do that, okay? Although I think it all should be in the open court. That's just the way I think it should be, but it is what it is. Idaho seems to be really loosey-goosey when it comes to doing everything in private. And the prosecutor claims that there exists a compelling interest at stake to preserve a fair trial. And this is what I get. No reasonable alternative exists but to conduct a closed hearing. Really? No reasonable alternative. It just blows my mind. I can tell you, other than if there's an issue about attorneys getting off the case, like I said, I don't believe I've ever done a closed hearing. 30 years of practice, never lock the doors. Maybe a juvenile matter, something, there was some privacy interest. It just doesn't happen, ladies and gentlemen. It's unbelievable to me that that's how they conduct these hearings. You could do this in any case. Oh, it's going to be embarrassing to the parties. Well, it's a homicide case. I hate to say it, but there's going to be embarrassing things. It's just the way it is. And I guess they're so worried about information getting spread. But we already know that doesn't matter. I don't know. We'll just leave it at that. Doesn't make sense in Idaho. Anyway, the state further motions the court for a scheduling order setting May 3rd for the defendants to file any notice of witnesses, exhibits, experts, and reports or other evidence the defense intends to rely upon for the hearing regarding the fourth and fifth motions to compel. That's the important part, ladies and gentlemen. Because remember, they were having the hearing on the whole issue of whether the surveying should have been allowed to take place, right? The defense is like, we got a witness, let's do this thing. And the prosecution was, well, we don't have it. And we've talked about it. He wasn't prepared. He's filing this because he doesn't want to get burned this time again. He wants to be able to see and be prepared for the motions hearing and say, hey, I want to know what what witnesses you're going to have, if they're going to rely upon anything, etc. Because apparently the prosecution can't function without their safety net there. So very interesting. But on the other hand, it is fairness that if you're going to have a hearing, you're going to call witnesses, you should disclose all that stuff too. But I kind of like the good old days, like the Wild West, gunfighters. Let's just go in and let the chips fall where they may. It's just kind of fun sometime to watch. All right, the upcoming Karen Reed case. Why? Why did somebody not tell me about this case? This sounds so interesting. I really had no idea this case was going on. There's only so many hours in the day. It's just Frank and I. But if you have an interesting case, send it to us, all right? Send it to us. Say, hey, what about this? I'll try to cover it. I promise. All right? So the Karen Reed case. The judge presiding over the case of Karen Reed, yes, the woman who accused of killing her Boston police officer boyfriend, has ruled on several motions, and stage is now set for the opening statements on Monday. The judge confirmed that the trial will now be moved to a smaller courtroom after Ms. Reed's attorney expressed concern of the layout courtroom where the jury could not actually see the witness testify. That's big, right? You have to be able to judge the witness's demeanor on the stand, their credibility, their ability to recall what they perceived. It all comes down to being able to see people. That's how you do it. And if the jury, when they were sitting, would only get the back of the head of the witness, well, it really wouldn't be doing what our judicial system requires, which is they'd be able to judge the credibility of the witness. Now, the judge noted that since they are in a smaller courtroom, that the media, the actual trial participants, and family would be assured seating in the new courtroom, but probably that's about it. So, as we discussed the other day, Miss Reed is charged with running down John O'Keefe, her Boston police officer boyfriend, and then leaving him allegedly to die in a blizzard in the town of Canton back in January of 2022. She's pled not guilty to those charges of second-degree murder, motor vehicle manslaughter, and leaving the scene of a collision in connection with Mr. O'Keefe's death. Now, Reed's defense has argued that she is being framed and that O'Keefe was beaten and attacked by a dog inside the home of another Boston police officer where he was being dropped off at. And the prosecutors claim that a piece of hair found on the back of Miss Reed's Lexus implicates her in O'Keefe's death. Now, according to the judge, when opening statements get underway Monday at 10 a.m., the defense and the prosecution will each get 45 minutes to present their opening statement. Remember, opening statements are not evidence. It is a roadmap of where the jury can anticipate the evidence leading you throughout the process. Now, neither side will be allowed to use exhibits during their opening statements, and that makes sense because that makes sure that the jury doesn't see things that are not going to be admitted into evidence. Yes, it varies by judge to judge. Some say if you have a good faith basis that you believe the evidence will be coming in, or if there's a stipulation among the parties that you can use exhibits, then that's okay. Interesting to see that no exhibits are going to be used. Going to be an interesting trial. I hope I get time to watch it all, at least in the daylight hours. If not, I'll have to watch it in the evening because I got nothing else to do. Update on the Richard Allen case. All right. Special Judge Francis C. Gull has approved a subpoena that grants the Carroll County prosecutors access to personnel records of the former Rushville police chief as part of the investigation as it relates to the Delphi double homicide case. Prosecutors believe that Todd Click's investigation into whether Odinists were involved in the killing will make him a witness for Richard Allen's defense. So, in a motion filed this week, prosecutors indicate that Click's employee records will show cases of untruthfulness and credibility problems. So the judge has ordered that the Rushville Police Department to turn over those records to the prosecutors within 30 days. Now, we got some more Delphi news for you, but let's talk about that. Isn't that interesting? Now, I understand some jurisdictions are very different, but in one of the jurisdictions that I practice primarily in, if an officer has an issue related to their truthfulness or some sort of personnel misconduct that would be in their personnel file, we get a little asterisk that says there may be something worth noting. So you then send over a subpoena and you show up to court, and then the prosecutor moves to quash the subpoena, saying, well, you don't know what you're looking for. It's like, well, I don't know the specific incident, Your Honor, but I do know that there's something there because the district attorney's office told me by indicating this little asterisk here. And then, of course, the judge will usually deny the subpoena, quash the subpoena, so you cannot get access to that because you don't know the specific instance of this misconduct and whether it's related to this, and therefore it's just a big fishing expedition. But apparently somebody in that police department must have tipped off the prosecutors to say, hey, this detective must have something in his file. Go get it. I always think that's interesting as well because if the government wants something subpoenaed, they get it just like that. The defense always gets their motions quashed. We'll wait and see. It's going to be interesting. Next, the Delphi suspect, Richard Allen's attorneys, want prosecutors sanctioned for what they're calling not turning over the evidence in a timely manner. Apparently, that includes preventing the jury from seeing video taken from one of the victim's cell phones. Now, the attorneys for Mr. Allen allege that evidence they recently found buried in other reports indicates that an Indiana State Police detective was in contact with the Manatee County, Florida Sheriff's Office about what they call a third-party suspect. They allege that the Florida police sent a tech to get a pair of the suspect's jeans that appear to have blood on them. Now, Allen's attorneys allege that they haven't found anything to indicate whether the Indiana State Police ever tried to test the blood for DNA or where that report would actually be found. The attorneys for Richard Allen also allege that the data taken from Liberty German's cell phone contain images of Abigail Williams and a purported suspect that was taken at 2:13 on the afternoon where the girls were murdered. That evidence wasn't given to defense attorneys until September 8th of last year, roughly 9 months ago, later than what was mandated by the rules. Now, the attorneys are also asking the judge to sanction the prosecutors by instructing the jury that prosecutors had the evidence and that it tended to exonerate Mr. Allen on May 1st, but they didn't turn it over for his attorneys for 4 months, which is in violation of the rules. I'm not sure they're going to get a jury instruction for that, but it's certainly ripe for cross-examination. The attorneys also want the judge to prevent prosecutors from using any data or information taken from Liberty German's cell phone during the trial. I'm not sure how the defense intends to do that other than this sanction, but I don't believe that the court is going to grant a sanction for late discovery. The remedy is not a sanction of don't use it necessarily, but the judge would say, are you asking for a continuance, Mr. Allen and attorneys? That's really the sanction. a continuance. So I know you would think, hey, you didn't turn it over, you shouldn't be able to use it. But prosecutors oftentimes say, well, Judge, there was no bad faith. It's a big case. We thought we turned it over. No harm, no foul. But if the defense wants a continuance, obviously we won't object. I know it's frustrating. You think the rules apply to everybody, but they don't. I was talking to a friend. He was in court on a particular matter. It doesn't matter, but the judge set certain deadlines, and the other party hadn't complied with any of the rules, and the hearing had to be continued. And my friend said, well, Judge, when I see a court order, I'd say you shall comply. You shall do what is ordered to do by a certain date. But yet the other party doesn't seem to do so, and there's never any sanctions. And the judge kind of like, well, I guess I kind of see that these orders aren't being complied with and that people just poo-poo them. But that's what happens when judges don't enforce those orders. I was once told by a judge, I really appreciate you filing the response that she had requested by a particular date. And I said, well, why wouldn't I? It's a court order. And she said, oh, you'd be surprised. So it's the judges that need to hold the attorneys accountable so that people actually comply with the orders. And they turn discovery over when it was supposed to be turned over. Just something to think about, ladies and gentlemen.